Regulation 31 is about holding of securities and shareholding pattern. Each company needs to separately file the shareholding pattern for its separate class of securities. There are three events or three times at which the requirement arises. One, at the time of listing of its securities, so which is 1 day prior to the listing of securities. Those which are already listed, in such cases on a quarterly basis within 21 days from the end of the quarter, and if the entity has any capital restructuring which results in change in exceeding 2% of its total paid up capital, in such event within 10 days of such capital restructuring, the entity needs to file its shareholding pattern with the stock exchanges. However, in case of specified securities on the SME exchange, this requirement is not on a quarterly basis but on a half yearly basis, and within 21 days from the end of each half year, the shareholding pattern needs to be filed by such companies. While SEBI has prescribed that 100% promoter holding should be in DMAT, which requirement was initially introduced way back in 2010-11, now they have specified that the shareholding of promoter has to be in 100% except where the shares are sold in physical but are not lodged in for transfer. So it's a transitionally period where the shares could have been sold in physical but not completed through the transfer procedure, or if the matter is sub judice before the court or tribunal, or where shares cannot be dematerialized due to death of any promoter. So only if at all the promoter shareholding is not dematerialized for any of these three reasons, the company gets exempted from the requirement of having 100% promoter holding in DMAT. Otherwise, the companies need to ensure that 100% of its promoter holding is held in dematerialized form. Regulation 31A is about disclosure of class of shareholders and conditions for reclassification. So as we saw initially on 2nd September 2015 when the regulations were introduced, this was another provision which was made applicable with immediate effect. This is particularly about the classification of shareholders as either promoter or public and in case of reclassification therein. So all entities which are falling under the promoter or promoter group shall be disclosed separately in the shareholding pattern. And if there is any modification or change in such classification either due to open offer or if at all the entity becomes professionally managed, such reclassification shall also be disclosed to the stock exchanges, and in certain cases it can be done only now with the prior approval of stock exchanges. Such situations can be where public to promoter and where the person holds more than 10% of the paid up equity capital, or if at all it is a classification from promoter to professionally managed where he holds less than 1% of the equity or convertible securities, and in such cases there can be no special rights or privileges, or all previous agreements shall stand cancelled, and such promoter shall not act as KMP for more than 3 years. Of deviation or variations. So if the entity has made a public issue and then if there are any deviations in the use of its proceeds from what has been described in the offer document, a statement needs to be filed with the stock exchanges. So this statement is to be filed on a quarterly basis with respect to public issue, rights issue or preferential issue, indicating deviation if any in the use of proceeds from the objects stated in the offer document or the explanatory statement issued in the notice of general meeting as applicable. This needs to be provided indicating category wise variation to show that capital expenditure, sales and marketing expenses or working capital etc. between the projected and actual utilization of funds. There will be comments or reports received from monitoring agencies which also need to be disclosed to the stock exchanges. and in case of the entities listed on the SME exchange, this requirement shall be complied on a half-yearly basis. 3 is about financial results. This is corresponding to clause 41 of the listing agreement, which now has been providing the requirement in separate sub-regulations which talks about how the financials are to be prepared, how they are to be approved, and how they are to be disclosed to the stock exchanges. The requirement states that the financial results shall be prepared on the basis of accrual policy and in accordance with the uniform accounting practices. Now, the companies need to understand what are the accounting policies or accounting standards applicable to it and accordingly prepare the financial statements. The auditor to be appointed shall be subjected himself to the peer review process of ICAI and should hold a valid certificate issued by the peer review board. The accounting standards IFRS, GAAP, or how it is exactly applicable to the company shall be disclosed as specified in Part A of Schedule 4. The financial results shall now be approved by the board, which earlier could also be approved by the committee. In case of financial results, the CEO and CFO shall certify to the board that the financial results do not contain any false or misleading statement or figures and do not omit any material fact. This is a quarterly requirement which the CEO and CFO need to provide along with the financial statements. The financial statements shall be signed by the chairperson or managing director, or in their absence any other director authorized by the board. So this is now a particular requirement specified under the regulation that only the chairperson or managing director or a certain director authorized can only sign such financial results. It further states that the limited review report shall be placed before the board. So in case of the quarterly financial audit, there will be a limited review of audit and such report shall be placed before the board. In case of the company having subsidiaries, it needs to provide the standalone financial statements as well as consolidated financial results to the stock exchanges. The entity then needs to inform the stock exchanges in the first quarter itself whether it will provide the standalone results or consolidated results during the year. No change can thereafter apply till the end of the financial year. In case of quarterly financial results, they shall be submitted within 45 days of the end of the quarter, and in case of the annual financial results, a timeline of 60 days has been provided in the regulations. Apart from the financial results, a statement of assets and liabilities shall also be provided at the end of each of the half year. In case of audited financial results, they shall be accompanied by the audit report. The audit report can be either with the modified opinion, that is, the audit can be with the qualifications, or it can be with unmodified opinion, that means there are no audit qualifications. In case of modified opinion, the company needs to submit a statement on impact of audit qualifications. This was amended in May 2016 and made effective from 1st April 2016. Similarly, in cases where there are unmodified opinion, the companies shall furnish a declaration that the audit report and the financial results are with unmodified opinion. When the SEBI came out with this amendment in May 2016, most companies had filed their financial results in the intervening period from 1st April till 25th May 2016. Therefore, SEBI along with the stock exchanges came out with a clarification stating that in case the results were filed with unmodified opinion, which were to be filed with Form A earlier, there need not be a fresh submission under the amended regulation. However, if the results were filed with modified opinion of the auditors, the companies were required to submit the statement on impact of audit qualification even if they were filed between 1st April 16 to 25th May 16. The requirement of half-yearly submissions is only applicable to the companies listed on the SME exchange, and year-to-date requirement is not applicable. It states that the companies shall submit the annual report within 21 days of it being approved by the company. Now earlier there was some confusion in the first year whether within 21 days would mean before the date of AGM or after the date of AGM. However, stock exchanges have clarified that this requirement is after the AGM and the companies need to submit the annual report within 21 days of the AGM. The annual report needs to contain audited financial statements, consolidated financial statements, cash flow statements, director's report, management discussion and analysis report, and other disclosures as applicable under the Companies Act 2013 and Schedule 5 of the listing regulations. The regulation further provides that a business responsibility report shall be submitted by the companies, which earlier was applicable for only top 100 listed entities based on the market capitalization. This requirement was amended in December 2015, which now applies to top 500 listed entities based on the market capitalization. So all such entities which are falling in the list of top 500 now need to additionally submit a business responsibility report, which it says that can be provided or can be hosted on the website, and necessary information can be provided in the annual report.